Right. The Honorable Trial Chamber of the International Criminal Court is now in session. The bench is presided by Honorable Mr. Justice Amity Roy, co-chaired by Honorable Mr. Justice Rajiv Bhalla, Honorable Mr. Justice Sanjeev Sachdeva, and Honorable Mr. Justice Vibhu Bakru. The cases listed for hearing today are the prosecutor versus Mr. Bogur and the prosecutor versus Major General Uttar. You may all proceed.
Counsel takes permission to approach the trial. We please the Honorable Court that counsel on behalf of the prosecutor is in front of the Honorable Bench in the case of prosecutor versus Mr. Bogur and prosecutor versus Major General Uttar. Your Excellency, the side of the prosecution shall be dealing with four contentions in the course of the argument. Firstly, that Mr. Bogur is guilty of committing crimes against humanity under Articles 71A, 71E and 71I. Secondly, that Mr. Bogur is guilty of committing war crimes under Article 82I and 82B. Your Excellency, the first two contentions shall be dealt with by me. Thirdly, that Major General Uttar is guilty of committing crimes of genocide under Article 6 of the IPC statute. And fourthly, that Major General Uttar is guilty of committing crimes against humanity under Article 71A, B and H. Your Excellency, the final two contentions shall be dealt with by the co-counsel. Your Excellency, I would now like to take a minute to brief the Honorable Bench about the facts of the case. Your Excellency, Mr. Bogur is the President of Netherlands and he was elected to a referendum in 2004. Your Excellency, the referendum through which his election was facilitated was challenged to the Supreme Court and the matter is still pending. Your Excellency, in 2012, citizens of Netherlands unsatisfied with Mr. Bogur's autocratic rule started protesting. Your Excellency, these protests continued and intensified. Your Excellency, on his death toll crossed over 2,000. In the course of these protests that took place and the turmoil that caused in Netherlands, Your Excellency, there were various instances of use of arbitrary use of violence, biochemical weapons, and torture by the Netherlands government on its citizens and also the citizens of other countries. Your Excellency, even Major General Uttar, a national black line, and his army of Green Terrorists infiltrated the state of Netherlands. He wanted to create a pure state of the North Star case. Your Excellency, in the pursuit of this policy, he carried mass beheadings and killings in furtherance of this policy. On 4th April, the Netherlands army launched a biochemical attack against the state of Netherlands, which was a neighboring country. The Green Terrorists were also part of this attack. The countries of Netherlands and Netherlands are both parties in the IPC statute, and the prosecutor has approached the Honorable Bench under Article 15 of the IPC statute. Your Excellency, I would now like to take the permission of the Honorable Bench to commence with the first contention. Much obliged. Your Excellency, the first contention that the prosecution is taking up is that Mr. Bogur is guilty of committing crimes against humanity against citizens of Netherlands under Article 71E, that is imprisonment or other severe deprivation, and Article 71I, that is enforced disappearance, under the principle of command and responsibility under Article 28 of the IPC statute. Your Excellency, crimes against humanity are mass crimes committed against the civilian population. In the course of this contention, I shall be taking up three basic issues, Your Excellency. Firstly, that the Green Terrorists were working in collusion with the Netherlands army. Secondly, that the common contextual elements of And this goes on to show that they're working in furtherance of the state policy, that excellency, the state policy seeks to quell the rebellion of the members of FRS. Your Excellency, this makes it clear that Mr. Bogo was exercising effective degree of control over the green terrace, which is necessary for the application of principle of command responsibility in the Eastern case. Your Excellency, Mr. Bogo also failed to exercise reasonable and necessary measures to prevent the commission of the crime in the first place. And Your Excellency, once they were committed, he did not initiate any kind of proceedings against the perpetrators of the crime, which he should have. Your Excellency, moving on to the next issue, that is the common contextual elements that need to be fulfilled for an ordinary act to be related to the level of crime against humanity. Your Excellency, as elaborated in the case of prosecutor Mr. John Paul Arthur, the number of victims of an attack is indicative of the widespread nature, while the existence of the policy of the attack is indicative of the systematic nature of the attack. Your Excellency, as can be seen, on 4th April 2014, 18 civilians and 4 medical relief workers were abducted and later on executed. Your Excellency, this has been explicitly stated in para 17 of the line 4 of the fact sheet. Your Excellency, as far as the systematic nature and Mr. Bogo's intent is concerned regarding the attack against Julian, he was aware of the pre-existing conflict between his government and the members of the FRS. Your Excellency, this goes on to show that it was his intention to carry out the attack as part of his policy to stop any aid, humanitarian or otherwise, from being given to the members of FRS. Your Excellency, it is this single act against the citizens of Julian which will be the overall context of crimes against humanity. Your Excellency, coming on to the specific charges that the prosecution is charging Mr. Bogo with. Your Excellency, for the crime of 7 months each, that is imprisonment or other severe deprivation in violation of fundamental rules of international law and concern, it will be applicable if the perpetrator shall imprison one or more of the persons or deprive them of their personal liberty or movement arbitrarily without any legal procedure necessary. Your Excellency, it can be seen that as a result of the abduction by the green terrace of the civilian citizens, of the unarmed civilian citizens of Julian, Your Excellency, they were deprived of their personal liberty or free movement. Your Excellency, they were imprisoned for 4 days, and there were eyewitnesses who saw that the civilian citizens and the relief workers were being carried across the border to residents from Julian. Your Excellency, this can be seen in para 16 of 912. Further, Your Excellency, moving on to the second charge that the prosecution is charging Mr. Bogo against, that is Article 71I, enforced disappearance. Your Excellency, a person must be arrested, detained, or abducted with the support or authorization of the state or organization, followed by refusal to acknowledge that the deprivation of freedom or give information of the state of the victim. Your Excellency, it is only submitted before this honorable court that in para 9, 18, line 1 of this fact sheet, the government refused to give any information on the state of the victim or their location. Wherein, Your Excellency, as has been sought to establish by the prosecutors, there was a collusion between the Green Berets and the Red Line Army, and hence the Red Line Army had knowledge about the state of the victims and their whereabouts, but they still chose to not divulge any details of it, Your Excellency, and hence Mr. Bogo is guilty of the charges of 71I and 71E. It is humbly and reverently prayed before this honorable court that Mr. Bogo be held guilty to the charges of 71E and 71I under the principle of command responsibility of isolating statute. If the honorable bench is satisfied with the first contention, counsel seeks permission to move on to the second contention.
Ma'am, 2 questions. First, you say that there was ample rehearsal between the Green Beret and the Red Army, and that should be used only for the fact of recovery of some rifles bearing the logo of the Red Army. You think as a prosecution that is enough? Number 1. Number 2, we find from the records that it's only some video clippings and the newspaper reports which form the foundation of the charge. Do you think that these 2 are enough to prove the charges that you are bringing against Bogo? Thirdly, see, you mentioned about non-disclosure of information about the whereabouts of the persons who were taken in. We remember and we recall that here is a case not against the state. Neither the state of 8th-10th nor the state of Blackland from where Zeta had come, whatever it is, nature to follow. Now, is it the responsibility of the state in such matters where the prosecution is against an individual to disclose the information?
Regarding the first query of the Honorable Bench, Your Excellency, as per the, in light of all the evidence that was found, Your Excellency, it can be reasonably inferred that they were working in collusion. Further, Your Excellency, when...
Sorry to interrupt you. In being a criminal trial, is there any place of presumption?
Your Excellency, counsel is, for prosecution shall try to establish that the green parents is working in collusion with further the coincidence.
Yes.
Your Excellency, the fact that the green parents made lightning advances into the state of Redland, while Mr. Bogo chose to take no action against them, Your Excellency. The fact that there were
Can I just interject?
Yes, Your Excellency.
Are we prosecuting or are you prosecuting on what principles? Is it the accused is to be proved guilty by you or is it the European system?
Your Excellency, in the trial chamber,
If the accused has to prove himself innocent, what is the principle applicable?
Your Excellency, the prosecution must prove beyond reasonable doubt that the guilty, in fact, guilty of the crime charged. Your Excellency, coming back to the query with the Honorable Bench, the first query, Your Excellency, under the overall control doctrine and the laboratory case of prosecutor was established, the state has to finance, equip, and be involved in the military operations. They should be planning, or they should be involved in the planning of the military operations, Your Excellency. Your Excellency, as far as the finance.
Interruption again. Is it your case that the state has funded Mr. Boga?
Your Excellency, financing, as far as financing is concerned, it is not stated in the fact sheet, Your Excellency, but the fact that the equipment was given to the green parents. Further, Your Excellency, they were involved in the planning of their military attack, as can be seen that were present and participating in the attack of 4th April, Your Excellency. Your Excellency, an attack against the citizens of Blue Land, an attack of that level, the knowledge of that attack could not have been gained by the green parents, Your Excellency, unless and until they were working in collusion with the Red Land Army.
I'm sorry, I think if we accept your arguments, we'll be acting on presumptions in the law. As you have rightly pointed out, there are certain provisions in the statute itself which gives at least 3 primary safeguards to any person. Right to remain silent, right not to be compelled to give evidence against himself, and the exclusive burden of the prosecution to the charge. So, is there any room for any presumption here?
Your Excellency, in light of everything that was happening and the evidence that points towards the fact that they were working together, Your Excellency, when it is all seen together, it can be said that they were in fact working together and in collusion. Your Excellency, coming to the next query, the state had a duty to divulge the details of the whereabouts of the victims, Your Excellency, as the prosecution contended that they were working together, and if the government had, which the prosecution believes they did, had the knowledge of the attack, Your Excellency, they should have inducted the information, but Your Excellency, they did not, and that is the reason that they are guilty under Article 719. If the bench is satisfied, I come to the commission who wants to say.
The next point, will reserve a judgment.
How much obliged, Your Excellency. Your Excellency, coming to the second contention, the Commission of War Crimes for Mr. Boga under Articles 8.2a and 8.2b. Your Excellency, it is an essential element for application of Article 8.2a and 8.2b to be applicable, that the conflict be an international conflict. The second contextual element that Your Excellency is sought to be established is that the victims of these attacks were protected victims under the One of the Geneva Conventions. Your Excellency, the prosecution is charging Mr. Bhogal under 9 counts. Firstly, willful killing, torture, willfully causing great suffering, appropriation or destruction of property, intentionally directing attacks against civilian population or individual civilians, intentionally directing attacks against civilian objects, intentionally directing direction of attacks against humanitarian assistance camps, and the targeting of educational institutions, and Your Excellency, the use of biochemical weapons. Your Excellency, the charge of willful killing can be seen in para 5, line 7 of the fact sheet. It states that in August 24th, the Red Army launched an attack on the peaceful protesters, Your Excellency, and it resulted in the death of 2,000 protesters, Your Excellency. Further, Your Excellency, in para 7, line 3, the Red Army paramilitary force used mortars and machine guns on the protesters, Your Excellency. Your Excellency, this is a violation of the doctrine of proportionality, Your Excellency. It is not seen that on a civilian population or protesters who merely voicing their opinion in a democratic country, which is a basic right, Your Excellency, the use of machine guns and mortars in the civilian population. Hence, Your Excellency, Mr. Bhogal should be charged under Article 8(2)(a)(1). Council, please permission to go to the second charge. Your Excellency, the second charge of prosecution is charging Mr. Bhogal is 8(2)(a)(2), that is torture. Your Excellency, actually in para 4, there were 12 teenage boys who were arrested, Your Excellency, arrested without warrants and kept in police custody, Your Excellency, and charged and tortured, Your Excellency. Actually, Your Excellency, Mr. Bhogal had no right to torture 12 teenage boys. Had no right to torture these 12 teenage boys, Your Excellency, and hence Mr. Bhogal should be charged. Further, Your Excellency, after one incident of torture taking place, there was another incident. Mr. Bhogal did not learn from his mistakes. There was a incident of torture which took place in para 8, that is a 13-year-old boy who was arrested, Your Excellency, resulting in his death, Your Excellency. Further, Your Excellency, even though Mr. Bhogal vowed to reform the country and take it back to its state of previous glory, this did not result in that. Your Excellency, the incident kept happening again and again, and it caused grievous harm to the citizens and to this poor boy, Your Excellency. Further, Your Excellency, the state of Redness is a party to the UN Convention against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment. Your Excellency, being a party to the statute, the state of Redness still committed this grievous harm and the act of torture on two separate incidents. The first being the 12 teenage boys and the second being the 13-year-old boy, Your Excellency, and hence Mr. Bhogal should be charged under Article 8(2)(a)(2). Your Excellency, coming to the third charge, which will cause great suffering. Your Excellency, on September 12, 7 civilians were killed and 23 were grievously injured. Your Excellency, and there was no sort of remorse on Mr. Bhogal's part. There was no condolences given by Mr. Bhogal that he was, in fact, this was not in fact done deliberately by Mr. Bhogal. This goes on to show that it was his agenda to cause the harm to the civilian population of Redmond. Your Excellency, further, on 1st October 2012, there was a protest in which women and elderly were part of it. Your Excellency, this was a very peaceful protest, and the Red Army used sophisticated weapons to quell this rebellion. Your Excellency, due to Mr. Bhogal enlisting children below the age of 16 who were not even trained, and the fact that they used sophisticated weapons to quell this rebellion goes on, it resulted in the army hitting civilian citizens with blue, Your Excellency. This goes on to show that Mr. Bhogal actually did cause great suffering to them, Your Excellency, and hence Mr. Bhogal should also be charged under Article 8(2)(a)(3). Your Excellency, next charge under the prosecution is taking up is appropriation or destruction of property, that is 8(2)(a)(4). Your Excellency, Mr. Bhogal, the Red Army targeted, Your Excellency, they specifically targeted and destroyed schools and hospitals, which is specifically stated in para 9 and 16. line 6 Your Excellency, which states that the Red Line Army targeted these Your Excellency, knowing that hospitals are protected under the Geneva Convention specifically. Further, Your Excellency, these hospitals in the country, like Red Line, which was in such a state of which a conflict with international nature, hospitals are very important to the civilian population, Your Excellency, and the extensiveness of this can be seen by the fact that there is a shortage of basic amenities in medical care for subsequently. Moving on to the next charge, Your Excellency, intentionally directing attacks against civilian population or individual civilians, which is the charge of 8-2B1. Your Excellency, it has been stated the attack of 4th April was intentionally directed against the civilian population or individual civilians, Your Excellency, as can be seen by the fact that this was actually directed by the paramilitary forces of the Red Line Army. Your Excellency, and this attack led to the abduction of victims of the citizens of Blue Line and later their execution, Your Excellency, which goes on to show that Mr. Bogar directed the attack or ordered the attack of 4th April 2014. Your Excellency, the next charge in the prosecution is dealing with is intentionally directing attacks against civilian objects, which is 8-2B2.
I'm sorry for the intervention again. Now, can you tell us from where you borrow this concept of war crimes?
Your Excellency, the concept of war crimes was first taken up in the Nuremberg trials.
Is it a part of the Geneva Conventions?
Your Excellency, the war crimes are not explicitly a part of the Geneva Convention, Your Excellency, but they have been.
Concept?
Your Excellency,
does it have anything to do with international armed conflict?
Your Excellency, for war crimes to take place, the conflict has to be international in nature.
Now, if it is a concept of international armed conflict, who are the parties to the conflict?
Much of that,
Who ought to be parties to the conflict? Two states, two warring states.
Your Excellency, a conflict may be international in nature when there is colonial domination, alien occupation or racist regime, or when the two contracting parties are in conflict with each other, armed forces in conflict.
Are you clear on the question? Can we think of international armed conflict, war crimes, because two states in war? If two states are not in war or in conflict, can we think of international armed conflict and therefore war crimes?
Indeed, Your Excellency, there is a colonial domination, racist regime or alien occupation, it can still qualify as an international armed conflict.
Can you substantiate your plea?
Your Excellency, Council, please ignore the case on the ground.
See, the consequence immediately would be that if you are charging Bogar on the imputation of war crime, you have made your reference to Geneva Conventions. We know what the Geneva Conventions say about these war crimes and what are the protections given. If there is no international armed conflict in a situation of the kind that is in the brief, can there not be an immediate reduction or conclusion that the very basis of war crimes is honest in your case?
Your Excellency, Council would like to elaborate on how the conflict was in fact international in nature.
So that would presuppose the clarification that is being seeks from you that even in case of colonial domination, international armed conflict is conceived of. Unless you can tell us that the facts in the brief very clear, two states are not in conflict. Blue Line has not retaliated. It's one way from the Red Line only. So there is no two states in conflict or in war against each other. And if there is no concept of international armed conflict, can war crime be a possible and considerable ground of charge?
Indeed, Your Excellency, Council seeks permission to elaborate on the internationalization of the conflict.
Please clarify if possible on the concept of international armed conflict vis-a-vis war crimes, so that we can appreciate the charge brought against Mr. Bogar.
Much like Your Excellency, the character of the conflict is relevant international. Your Excellency, there are various acts of external aggression against the state of Red. Your Excellency, this can be elaborated and substantiated by the fact that on 26 August 2012, a foreigner was apprehended on the premises of the prison. Your Excellency, Your Excellency, this can be substantiated by the fact that the General Ambassador of Black had also released a statement saying that the Alpine Hand was directly supporting the members of FRS. Further, Your Excellency, the surge of anger amongst the protesters increased to the northern borders subsequent to Bluland opening its border to the refugees. Your Excellency, this goes on to show that Bluland was in fact exerting influence on the citizens of Britain to act against the state.
Before we go to the facts, would you tell us what legal principles or legal ingredients would be required to establish the international case rather than why would it not be a personal conflict? What are the legal principles going on the facts are required under the Geneva Convention and otherwise to establish that it is an international conflict?
Your Excellency, additional protocol states that
Where can we find that article? Is it there in the paper?
Your Excellency, humble apologies, it's not in the complaint. However, Your Excellency, the additional protocol is.
I also have you charged you for international war crimes? And if so, what will be charged?
Your Excellency, Counsel for Prosecution has charged the defendant for the charges committed in an international armed conflict. However, Your Excellency, it is not under a definite article, but Your Excellency, in the light of the evidence seen that the prosecution shall seek to establish, make the conflict an international armed conflict.
Let me come back to the first question. This is for personal acts, not acts by international entities as well as states.
Indeed, Your Excellency. Your Excellency, the involvement of other states can be seen by the fact that there were external acts of aggression. Your Excellency, Bluland was raising, as was proclaimed in the statute against and by the government also, that Bluland was raising an army of child soldiers, stone throwing soldiers, Your Excellency, and this was substantiated by the fact that there was a 13-year-old boy seen and who was the ringleader of this.
Do you believe that this charge can even otherwise be sustained without the state being a part?
Your Excellency, there are other instances also substantiated.
Even on facts, we are trying to know from a very primary and the fundamental principle of law. He was starting with the premise that directly are international armed conflict and trying to justify on the basis of the facts. State is not a party. State is not an accused. You have made the president of the state, in his capacity as the president, a party. Forget about the command responsibilities. There may be some scope here and there. But once you say it's an international armed conflict, can your charge against Boga in absence of state be otherwise sustainable?
Your Excellency, as to the queries, in response to the queries, the bench there was in fact involvement of states. There was the involvement of various states, Your Excellency.
And to accuse the state in absentia. Are you not charging the state in absentia?
Your Excellency,
Has there been any involvement in the state at any stages before the charge was made? We say this sequentially one after the other before the court, etc. Before the charge is made, what crimes? We are trying to know from you what crimes according to us would be supposed international armed conflict. International armed conflict would involve two warring states. Here is a charge of 8-to-B against President Boga of Red Hand. Red Hand is not a party. President cannot be synonymized with the state. And therefore, there is no international armed conflict if the charge is not against the state for what crimes 8-to-B. Will your charge be sustainable only against President Boga beyond the state? Number one. Number two, was the state of Red Hand at any point of time in the process of filling of the charge, investigation or otherwise associated? If not, what will happen to your charge? That is on 8-to-B.
Your Excellency, Your Excellency, the state itself was involved. The state of London also was involved. Because the external aggression practiced by the state was done to the civilian citizens itself. And hence, Your Excellency, state itself is involved is not just charged with Mr. Boga but also in the state. Your Excellency, Council please permission to elaborate on the internationalization of the charge.
We know the facts, these are the facts, which is carrying things. We are eager to know from you the concept of international armed conflict as Brother Sundar said, the principles, the parameters, the norms which define the international armed conflict, and how do you, if possible, correlate those with the facts to sustain your charge under 8.2A.2B. That is really the area where we are eager to learn.
Your Excellency, Additional Protocol 1, Article 14 states that a conflict would be international in nature when there is, as has been previously stated by the Council, when there is a colonial domination, racist regime, alien occupation, when two or more high contracting parties are in armed conflict with each other. Your Excellency, what the prosecution here is trying to do is that the crime of aggression states that when there is use of armed forces by one state against another state. Your Excellency, this is thought to be established by the prosecution that there was in fact use of armed force by one state against the state of Brethren. Your Excellency, further, since there was use of armed state by one state against another, and the UN sanction states that UN sanction was placed on the state of Brethren, Your Excellency, the UN sanction states that if there is a breach of threat, or there is a threat of if there is a threat of a breach of international peace or a crime of aggression taking place, then Your Excellency, the UN Security Council speaks put sanctions on the state. Your Excellency, the UN sanction itself is proof enough that the world global community thought that this was in fact an international conflict and had to intervene in the conflict itself. Further, Excellency, there were various external, the President of Zeta, who was the leader of the Green Rise, Your Excellency, was a national black man who created a lot of state chaos in the state, Your Excellency. It is probable that he was in fact sponsored by the state of black man and had come into the state of red man to create the chaos of destabilization.
You use the word possible. Your entire case goes into the realm of speculation. And which is alien to criminal jurisprudence. How do you justify that?
Your Excellency, in light of all the evidence seen in one place together, it can be inferred that there were various countries involved in the external influences.
The benchmark is beyond reasonable doubt, not inference, deduction, speculation.
Indeed, Your Excellency. Your Excellency, further, the fact that Brendan was raising an army of stone throwers, army of child stone throwers, Your Excellency, which is substantially the 30-year-old boy, goes on to show that they were firstly equivalent, secondly they were financially also involved, as they were giving remuneration of $75, euros from every for certain number of stones thrown. So Excellency, it seems that Julian was in fact involved in the army of child soldiers also. Your Excellency, further, the surge of anger among the protesters increased in London border itself, and after Julian opened its border, Excellency, which goes on to show that this was mostly all the protests happening in London border which was shared with Julian. Your Excellency, the state of Julian was influencing the people of citizens of Britain against its own government, which can be seen, Your Excellency, by the protests that were taking place against President Boga. Your Excellency, these protests started after 6 years of Mr. Boga already being in position of the state being a peaceful place and peaceful state. Your Excellency, this goes on to show that Julian was in fact acting involvement of various external influences goes on to show that this was an international armed conflict. Generally, coming to the second contention earlier, that the protesters were protected under one or more of the Geneva Conventions, the victims of these attacks are extended. Your Excellency, it is only stated before this honorable court that the victims be accorded the status of protected persons under one or more of the Geneva Conventions. Your Excellency, Article 4 of the Geneva Convention says that persons protected by the convention are those who, at a given moment and in any manner whatsoever, find themselves in case of a conflict or occupation in the hands of a party to the conflict or occupying powers of which they are not nationals. Your Excellency, as you may infer, the citizens of Redland are protected as they are not parties to the conflict or they are not a national entity. Since there is the lack of any occupying power, that does not apply in this case. But Your Excellency, the citizens of Blumen as well as the citizens of Redland who were subjected to these war crimes are protected persons under Article 4 of the Geneva Conventions. If the Honourable Bench is satisfied, my co-counsel would like to elaborate on the final two charges. It was indeed an honor and privilege.
We have noted very carefully your arguments, but as a prosecuting counsel, we would advise you, if we have the authority to do so, never ever in your arguments use by trying to place a charge, support a charge, prove a charge. The words inferable, probable, possible. These are all respectability. There is no place for these words or this concept in human experience. Otherwise, all right.
It was indeed a privilege arguing before the Honourable Bench.
Your Excellency, the Secretary please this Honourable Court, I shall be proceeding with the third and fourth contentions raised by the prosecutor against Major General Vita in the present case. Your Excellency, the first of these contentions is that Major General Vita is guilty of the crime of genocide against the San community. And the second, Your Excellency, is that he is also guilty of the crimes against humanity of murder, extermination and persecution under the principle of command responsibility. If the bench permits, I'd like to begin with the first contention. Much obliged, Your Excellency. Your Excellency, under the first contention, I shall be addressing three issues. Firstly, Your Excellency, that the acts of the Green Brigade constituted the crime of genocide. Secondly, that Major General Vita, as the military commander of the Green Brigade, is responsible for the same. And thirdly, Your Excellency, that he is also guilty of the crime of public and direct incitement to commit genocide. Your Excellency, counsel, there is a minute to take the report order, please. Much obliged, Your Excellency. Your Excellency, the crime of genocide is the systematic and intentional destruction of a racial, religious, national or ethnic group. Hence, Your Excellency, to constitute the crime of genocide under Article 6, it is essential that acts of violence be committed against a protected group and that these acts of violence, Your Excellency, be committed with a specific genocidal intent or total speciality. Your Excellency, it is submitted that the San community constituted a religious group in the country of Pradesh, Blackland and Uttar. Further, Your Excellency, the fact that acts of violence were carried out against this religious group, Your Excellency, is explicit from the fact sheet itself, wherein the same stated in paragraphs 14 and 17. Your Excellency, the fact sheet clearly states that a series of mass beheadings was carried out against the Uttar community, and that on another instance, Your Excellency, at least 7 members of the Uttar community were executed. Hence, Your Excellency, the second essential of the crime of genocide, that acts of violence be carried out against the San community is also satisfied. Your Excellency, the final and perhaps most essential element of the crime of genocide is the existence of a specific genocidal intent or dolus specialis. Your Excellency, it is submitted that an intent is an intangible factor that cannot be conclusively determined in the absence of a confession. It must be inferred, Your Excellency, from various facts and circumstances. The ICTU and ICTR jurisprudence, Your Excellency, has laid down certain tests to establish the existence of genocidal intent. Some of which, Your Excellency, are the presence of the genocidal policy, the nature and scale of atrocities committed, as well as the utterances of the perpetrators themselves. Your Excellency, it is submitted that in the present case, the most major indicator of the existence of genocidal intent on behalf of the perpetrator are the utterances of the perpetrators themselves. Your Excellency, the fact sheet clearly states that in a video uploaded by the Greenberries themselves, after beheading members of the San community, Your Excellency, they clearly stated that we shall eliminate the entire San community one by one. Your Excellency, the fact that these statements were made along with videos showing the San community being beheaded clearly indicates towards the presence of a genocidal policy and the intent to carry out this genocidal policy. Further, Your Excellency, Major General Zita himself declared the San community impure and called for the widespread elimination of the San community in order to purge the state and create a pure state. Hence, Your Excellency, it is clear from these facts and circumstances that the presence of the genocidal policy was in fact fulfilled, Your Excellency, and that there existed a specific genocidal intent on behalf of Major General Zita and the Greenberries to carry out the same. Your Excellency, if the bench is satisfied with this, I'd like to proceed to the second issue under the suspension. Much obliged, Your Excellency. Your Excellency, the second issue is that Major General Zita, as the military commander of the Greenberries, is responsible for the actions of the state. Your Excellency, under the principle of command responsibility, it is essential firstly to establish the existence of a superior-subordinate relationship. Your Excellency, this is indicated from a position of de jure authority, the exercise of de facto control, and an overall effective control exercised by the superior over his subordinate. Your Excellency, the fact that Major General Zita held a de jure position of authority amongst the Greenberries is explicit from the fact, Your Excellency, firstly, that the fact sheet states he was the head of the Greenberries. Secondly, Your Excellency, he adopted and used the title Major General in reference to himself. And thirdly, Your Excellency, that he was actively involved in the enlistment of soldiers into what is explicitly referred to as his army of Greenberries in paragraph 14 of the fact sheet, Your Excellency. And finally, that a simple declaration by Zita that he desired a pure state was immediately followed, Your Excellency, by a series of mass beheadings carried out by his subordinates in pursuance of the state. This clearly indicates, Your Excellency, that Major General Zita possessed both position of de jure authority as well as overall and effective control over his subordinates. Your Excellency, in light of this, it is submitted that Major General Zita, as the military commander of the Greenberries, must be held responsible for the acts of the same and is hence guilty of this kind of genocide in this present case. Your Excellency, it is further submitted that Major General Zita is also guilty of the crime of incitement, public and direct incitement to commit the crime of genocide. Your Excellency, the essentials under Article 25, Clause 3, subclause E of the Rome Statute to constitute public and direct incitement state that the incitement must firstly be public and direct in nature, and secondly, it must be committed with the requisite mens rea to cause genocidal consequences. Your Excellency, the existence of genocidal mens rea on behalf of Major General Zita has already been elaborated upon extensively and is explicit from his utterances as well as the nature and scale of atrocities committed by his followers. And Your Excellency, what remains to be established is that his incitement was public and direct in nature. Your Excellency, the public nature of incitement is indicated from the fact, Your Excellency, in the present case, that it was widely heard across the countries of both blacklist as well as redlist and elicited widespread and violent responses from his followers across the territory of both these countries. Your Excellency, further, the requirement of direct incitement does not mean that it cannot be euphemistic or metaphorical in nature. The standard required, Your Excellency, is that the words of the inciter and the intent of the inciter be explicit to the address. In the present case, Your Excellency, Major General Zita, as stated in the fact sheet itself, was a vociferous advocate of the use of violence and force. And Your Excellency, any call by Major General Zita, who his followers know is an advocate of the use of force, to cause the elimination of some community that he himself has declared impure, would naturally result, Your Excellency, in his followers interpreting this order of his as a call to kill these persons. Hence, Your Excellency, it is submitted that the incitement committed by Major General Zita is both public and direct in nature, and was committed with the requisite mens rea to cause genocidal consequences. And hence, Your Excellency, it is submitted that he is guilty of discharge as well. If the bench is satisfied, Council would like to proceed with the second contention. Much obliged, Your Excellency. Your Excellency, the second and final contention raised by the prosecution against Major General Zita is that he is guilty of the crime against humanity of murder, extermination and persecution under the principle of command responsibility. Your Excellency, to qualify as a crime against humanity, acts must be committed must be directed against the civilian population and committed, Your Excellency, these attacks must be widespread or systematic in nature and committed in furtherance of a policy. Your Excellency, the widespread nature of an attack is indicated from the number of victims of such attack, and hence, Your Excellency, it has a quantitative nature. In the present case, Your Excellency, the fact that the act carried out by the Green Berets was widespread in nature is explicit from the fact that paragraph 14 clearly states that a series of mass beheadings ensued. Hence, Your Excellency, the use of the word both series and mass indicate towards a large extent of victims and indicate that the acts were in fact widespread in nature. Further, Your Excellency, on one particular instance, the Green Berets uploaded a video of them executing, Your Excellency, 18 persons. Your Excellency, in other cases judged by the ICTY and ICTR, people have been held guilty, the accused have been held guilty for the crime of extermination, Your Excellency, for ordering the killing of even 16 and 17 persons. In the present case, Your Excellency, apart from a series of mass beheadings, on another particular incident, at least 18 persons have been killed by the Green Berets. Hence, Your Excellency, it is submitted that these attacks were in fact widespread in nature. Your Excellency, it is further submitted that these attacks were also systematic in nature as they followed a specific policy. The policy in this case, Your Excellency, was Major General Zita's vision and mission to create a pure state by purging the states of blacklist and redlist of communities, Your Excellency, that he had declared as impure. Hence, Your Excellency, the fact that all the acts of the Green Berets were carried out in pursuance of this particular policy clearly indicate that they were also systematic in nature. Your Excellency,
how do you substantiate this policy to the facts from the given fact sheet? Which fact would ask us to infer that there is this policy?
Your Excellency, the fact firstly, in paragraph 14, that mass beheadings were carried out, a series of mass beheadings were carried out against members of communities that had been declared impure by Major General Zita. The minute, Your Excellency, that he called for the creation of a pure state. Hence, Your Excellency, these mass beheadings were clearly carried out in pursuance of Major General Zita's policy and his declaration to create a pure state that was free from communities that he had declared impure. Further, Your Excellency, the next incident that is reported, the incident of killing reported by the Green Berets, Your Excellency, is an incident where 22 civilians and medical relief workers were executed on video, and the video was uploaded on a popular website. Your Excellency, the fact that with this video there was a voice in the background stating that this was a message being sent to all people who held communities that Zita had declared impure, and that this would be the same, the fate of the people who held these communities would be the same as the people being executed. Your Excellency, both these incidents clearly show the statements made along with the incident and the nature of the incidents, Your Excellency, clearly show that they were both carried out in pursuance of the same policy, which was the creation of a pure state. Much obliged, Your Excellency. Your Excellency, the specific charge of the crime against humanity of murder requires that Your Excellency the fulfillment of two requisites, that is the actus reus and mens rea. Your Excellency, the fact that murder occurred cannot be disputed in the present case when it is clearly stated in at least two paragraphs of the fact sheet that the acts of injuries resulted in the death of more than one person.
Can we just ask you a question? We are making of a statement. How do you infer mens rea on this part?
Your Excellency, the fact that Mr. Zita did not just make a statement but took positive actions to fulfill his wish, which was the creation of an army known as the Green Beret.
What is this positive action vis-a-vis the behavior, vis-a-vis the all those facts you told us? Apart from breaking a state, breaking a separate state, maybe somebody's some reason to do that. That would not be necessary to kill the other people. How do you? What are the facts?
Your Excellency, the fact that he created an army that was armed, equipped, and consisted of soldiers. Your Excellency, the purpose of an army cannot be to do anything other than carry out acts of violence against.
Almost every country in the world says we've got an army to defend ourselves.
Your Excellency, but Major General Zita's aim was not to protect his community from other communities, but to actively carry out acts against other communities to purge the state of the Your Excellency.
Have you been an investigation? Ruled out any possibility of they being under attack from the other side?
Your Excellency, there is absolutely no evidence indicating that any kinds of acts of violence were carried out specifically targeting the Orthodox North Star community, Your Excellency, which is the community that Major General Zita belonged to and proclaimed to be the only pure community. Your Excellency, there is no evidence of any kind of violence specifically targeting this community, and hence there is no evidence of this community being under attack from any party.
Your argument is that the video clippings in the area containing the declaration by Major General Zita that we have prepared these people because the country from the impurities, facing the community, this is the rest of the propagating or this of the religion and community. Do you not think that if the charge is based on that kind of a declaration, you are basing your charge on admission by the accused?
Your Excellency,
is it your case of admission of the charge by the accused?
Your Excellency, Major General Zita.
Number one. Number two, which is that provision of the statute which permits this kind of evidence to be admissible in law in support of the charge? Are you aware?
Your Excellency, the admission of such videos as evidence in the court is entirely up to the discretion of the bench.
No, we are not on that. We are not on the discretion. We are on the category of evidence which can be adduced, even if admissible. Are you aware of that particular provision of the statute under which such kind of material, either in the form of video, audio, that is admissible in evidence? And if so, vis-a-vis whose evidence is it admissible? This is in the context of your statement that these declarations prove the policy. These declarations prove that when there was a widespread and systematic elimination of members of a particular community. Now, if this evidence, this cannot be taken to be evidence as permissible under the statute, then can these statements or these disclosures or these, these materials form the basis of a charge?
Your Excellency, the first.
We can just refer to Article 69 of the statute. We just have a reference to clause 2 of Article 69 of the statute and find out what kind of evidence of this form is admissible, even if it is permitted by the court. Does it contemplate an evidence in the form of a declaration by an accused on the basis of whom, on the basis of which a charge can be framed? If the answer is no, does it not strike at the very root of your charge?
Your Excellency, addressing the first issue raised by Your Excellency, the videos showing the mass beheadings of members of the Sun community, Your Excellency, clearly contains statements by the perpetrators of the crime, Your Excellency, which may or may not have included Major General Zika himself. However, Your Excellency, the fact sheet clearly states that Major General Zika created his army with the sole intention of eliminating, and that he unleashed a campaign in the state of Blackland itself.
It's an improvable case because whether it is Zika himself or his supporters or followers from the University Army, they have made a declaration. And you pick up that declaration as a piece of evidence against him. Is it permissible under the statute to be used against the accused person?
Your Excellency, can you just get a minute to refer to Article 69 of the...
You see if Article 69(2) is of relevance.
Your Excellency, Article 69(2) states that Your Excellency, all videos containing such testimony provided by a accused person must be...
There is no use of what accused there. If I have read the text correctly,
by a witness, Your Excellency, refers to witness.
the word is witness, not the accused. And now if we remember that in a charge in a criminal trial, an accused cannot be comparatively witness against himself, can you use this declaration as a piece of evidence against him?
Your Excellency, the fact that the grievances themselves uploaded these videos of themselves making these declarations, Your Excellency, clearly admits that
What we are trying to indicate is this: if we are basing your charge only on these declarations made by the perpetrators, alleged perpetrators, not by Zika but by his supporters, makes the same community interest. Can you, following the fundamental principles of criminal jurisprudence and also the requirement of the statute that an accused cannot be compelled to be a witness against himself, use this material against him?
Your Excellency, counsel to the prosecutor is the belief that this evidence can be used against the perpetrators of the crimes committed by the victim.
On what principle?
Your Excellency,
Mind it. See, this is in the context that you have no other evidence to support the charge. There is no other evidence to support the charge except maybe the facts of these atrocities. Well, that is something different. Whether this can be taken judicial notice of, so that no proof is necessary. If no, is this declaration in the video footage?
instead of the charges against an emergency should not be against the principles of law in taking into consideration the fact that the victims of the crimes committed by these people must be given justice.
And we just bring your notice 64(9). Would your case require us to opine on the evidence in terms of 64(9)?
Your Excellency, 64(9) states that the trial chamber shall have the power on application of parties or on its own motion to rule on the admissibility of evidence. Your Excellency, as counsel for the prosecution has already articulated, the admissibility of these videos as evidence is completely rests upon the discretion of the sovereign bench itself. However, Your Excellency, it is
or 1 or 2%.
As the SCP and jurisprudence shows, video footage evidence is usually taken into consideration not as direct but as corroborated evidence in the presence of other evidence as well. However, there is in exceptional circumstances when the nature and scale of atrocities committed is as extreme as it is in the present case, and then the SNC, the admissibility of the fact that justice must be delivered to victims depends on the admissibility of such evidence. If your SNC is trained on Honorable Court to in fact admit the evidence of the videos as evidence in order to provide justice to the SNC. Master Your Excellency, the concerning specific charge of murder against Mr. Uttar and his Excellency and by extension Mr. Major General Uttar. Your Excellency, the crime of murder requires specific activities as well as misdemeanor. Further, Your Excellency, when this murder is committed on an extremely large scale and results in extreme mass destruction or a large-scale killing, it also amounts to the commission of the crime of extermination, Your Excellency. In the present case, Your Excellency, it is submitted that the scale of atrocity committed is also explicit from the fact sheet itself. Also, Your Excellency, from the wording of paragraph 14, which indicates that a series of mass beheadings ensue. And secondly, Your Excellency, the beheading itself in a video uploaded shows a killing of 18 persons. Your Excellency, the fact that the number of persons killed by the beheading is widespread and large in nature, Your Excellency, shows that the beheadings are purely taking a crime of extermination as well. Further, Your Excellency, the specific charge of persecution requires that an identifiable group or collective be deprived severely of their fundamental rights due, Your Excellency, to the fact that they belong to such groups. These fundamental rights, Your Excellency, also includes the right to life, which in the present case has been, Your Excellency, curtailed by the beheading. Your Excellency, the action in beheading resulting in the deaths of numerous members of the Sun community as well as the non-Orthodox North Star community clearly shows that they were being persecuted due to their Your Excellency, the fact that they belong to this identified collective and that they were being deprived severely of their right to life, which is a fundamental right, Your Excellency. Your Excellency, further in hate speech amounts to the crime of persecution. Your Excellency, the indictment committed by Major General Sita would qualify, in fact, Your Excellency does qualify as hate speech, and hence Major General Sita also committed a crime of persecution on account of his hate speech carried out by him. In addition, Your Excellency, it is submitted that Major General Sita is guilty of the crime against humanity and murder, persecution, and extermination under the principle of command responsibility.
Do you have any idea as to what happened in the basis of getting the charge against Major General Sita? Do you have any idea about what was the basis, what were the materials which were taken over for the framing charge against him?
Your Excellency, the plan and policy followed by him as well as the nature and scale of atrocity.
Who will be coming?
Your Excellency, the prosecutor took up, the office of the prosecutor took up the matter for Pure and initiated.
You have so all policy state or the state informations.
Your Excellency took it up.
Any idea for that doesn't work hard to be. We're asking a question beyond me, but any idea?
Your Excellency, the brief states that the prosecutor initiated the proceedings under Article 15. Article 15, Your Excellency, states that the prosecutor will take up a matter to Pure and investigate the admissibility of such matter. Hence, Your Excellency, the office of the prosecutor has taken a decision from the whole basis.
You have referred to hate speech. The hate speech, when you trace this hate speech to, again, some video clips.
Your Excellency, the fact that Major General Sita made declarations you
earlier said that all these declarations and this video clips of behaving, etc. These were made by his members of his then parents, not by he himself.
Your Excellency, the fact sheet is that videos are uploaded showing the marketing editing of members of the San community along with statements. However, Your Excellency, paragraphs 13 and 14 of the fact sheet stated as a given fact that Major General Zita had a wish for campaign and that in furtherance of this campaign, he declared certain communities to be impure and called for their elimination.
So your aim of establishing a nexus between Zika and the Greenberg is also based on these regulations in the video games.
In the controversy, again, paragraph 13 of the fact sheet clearly states that the Greenbergs were the extremist armed men that were headed by Major General Zika.
Here we want to know what is the basis of this nexus that you are trying to establish between Major General Zika and Greenberg. How? What is because of the green cap?
Not Your Excellency, the soldiers of the Greenbergs were extremist followers of the Orthodox North Star community who were working under Major General Zika, Your Excellency.
See, that's a statement of fact that you're making, that they were working in the system. We want to know from you. Because you have prostituted or you seek to prosecute Major General Zika. On the basis of the alleged, outrageous acts perpetrated by these Greenbergs. We want to know from you how to establish this nexus between Major General Zika and the Greenbergs. Again, on the basis of the video uploads.
Your Excellency, not only the fact that, Your Excellency, firstly the fact that they declared in their videos that they were carrying out Major General Zita's vision. And Your Excellency, the fact that Major General Zita did not condemn this or deny this in any manner. Your Excellency, an ordinary prudent man, if his name was being used, Your Excellency, to carry out atrocious acts that he did not condone or that he was not responsible for, would naturally take steps to deny the same or to condemn the same. First,
that's again you are resorting to this logic, wanting us to presume something.
Your Excellency,
accused in a criminal trial has a right of silence. I won't respond to the charge that is made against me. Does it absorb the possibility of the burden of putting the charge?
indeed not, Your Excellency.
So, see, the fact that, Major General Zika did not come forward and openly declare that all the state against me absolutely untrue. I am not getting this flow. I am not responsible. See, that doesn't make your case easy. Again, come back to the same question. Even if he is silent, is it the purpose of the prosecution to rely only on the video clippings and that to not by him, by his perpetrators, to form your charge against him in particular and not the perpetrators? It's only against him on the basis of the concept of command responsibility. Is it permissible?
Your Excellency,
Can you fall back on the concept of non-denial?
Your Excellency,
It is a right of silence.
indeed, Your Excellency, Major General Zita was not only the military commander, but also the religious leader of this faction of people. And Your Excellency, it is clear that he, as a religious leader, would also have exercised a substantial level of influence. Your Excellency, people who carry out widespread atrocities in the name of their religious leader, and Your Excellency, a person who has assumed this level of responsibility, was, Your Excellency claims to be a religious leader, would Your Excellency naturally take steps to either control or punish his followers for the acts he committed, or at least Your Excellency at the very least condemn the acts he committed, which Your Excellency Major General Zita took no steps to do in the present case.
We are aware of two concepts, made ritual and self-ritual.
Indeed, Your Excellency.
You want us to act on rituals, made ritual or self-ritual?
Your Excellency, the prosecutor begs that the bench act on the principle of self-ritual.
Are you aware that to act upon the concept of self-ritual, there is a necessity of a statutory dictate? Does the statute contain any dictate of the time asking a court deciding a charge against an accused person to issue obligating on the basis of certain basic facts. If that is not there, it is what is good to do things adversely related to only on facts and this type of evidence on the top.
Your Excellency, even how is the bench, apart from exercising the legal duty, also exercising the moral duty in the present day. And in light of your Excellency, the explicit videos and evidence indicating the guilt of Mr. Jayasuriya, that is how he plays this bench side.
We have just what you said. We have already gone to prosecute even if there is evidence. Is that the argument?
Indeed not, Your Excellency. There is not a paucity of evidence in the present case. The only problem in the present case, Your Excellency, as the bench has highlighted, is the technical issue of whether the evidence is admissible or not. Your Excellency, they say that the bench not allow such minor technicalities to come in our jurisdiction.
You start in the middle of your submission. You say extremist statements, legislative words. Now, extremist has to do the vanquished or the victor.
Your Excellency, Major General Zita was a believer in the use of force. Your Excellency,
You said extremist statements.
Indeed.
Legislative or the victors. So, how do you say that extremist?
Your Excellency, a religious leader who creates an army to carry out his vision, Your Excellency, in the Your Excellency, standard held by an ordinary prudent man would not naturally be considered to be extremist. Your Excellency, a religious leader who wishes to create a pure state could also propagate the ideals of his religion and wish to cause the people of other religions to want to convert to his religion. However, Your Excellency, he took the
The state says that the president of our country will have to be a Christian. Is that the extremist view?
Your Excellency, if the state says that everybody who wants to be the president but is not a Christian will be killed, then Your Excellency, that is an extremist view being taken by the state, as is the case in the present situation.
Will you refer to the last line of paragraph 13 of the bench?
Indeed, Your Excellency. Your Excellency states that the leader is going trained and supported by an influenced terrorism group. Your Excellency, naturally, Mr. Zita, as a religious leader, would not have had much experience in training armies, Your Excellency, and it is natural that he required assistance from an external source.
What you are saying is that because they were being trained by terrorist groups, they would fall into the category of extremists, rather than being trained by professionals as in military warfare.
Indeed, not Your Excellency. Your Excellency, the fact that
This was something in your favor.
Your Excellency, the fact that they approach a terrorist group to train them is indicative of the fact that they are extremist in nature. Is what the observation of the prosecutor is, Your Excellency. Your Excellency, like this, it is submitted as Major General Zita guilty of against humanity of murder, persecution, and extermination under the principle of command responsibility. Your Excellency, if the bench is satisfied, Council would like to proceed with the prayer. Much obliged, Your Excellency. Your Excellency, in light of the issues raised, arguments advanced, and authorities cited, it is humbly prayed before this honorable court to find against Mr. Bogus and Major General Zita guilty of all charges against them and pass any other order as the court may deem fit in the light of equity, justice, and good conscience. And with this act of kindness, Your Excellency, the Council of Prosecutors as the duty bound shall forever do. Much obliged, Your Excellency. Excellency, it has been a privilege argument before this honorable court.
Good afternoon, Mr. President and Excellencies. I am Defense Counsel 1 and it's an honor to appear before this court on behalf of the defense in the case concerning the charges filed against the defendant, President Booker of the state of Maryland, and Major General Zita, the self-styled commander of the Green Beret. Your Excellencies, in the course of our submission, I will speak for a total of 31 minutes, while my co-counsel will speak for a total of 29 minutes, with 5 minutes reserved for our survival. Your Excellencies, I will be addressing the first two charges against defendant number 1, President Booker of the state of Maryland. Your Excellencies, defendant number 1 has been wrongfully indicted for 2 counts of crimes against humanity against the people of Uttar, and also wrongfully indicted of 7 counts of war crimes under the Moot statute. Subsequently, Your Excellencies, my co-counsel will be addressing the third and fourth charges against Major General Zita concerning the crime of genocide and 3 counts of crime against humanity. With the due permission of Your Excellencies, I would now like to move on with my submission. Thank you, Your Excellencies. Your Excellencies, it is the contention of the counsel in the defense that this present case is outside the jurisdiction of the International Criminal Court. Your Excellencies, the instant cases have been initiated by the prosecutor, Sumo, under Article 13, Clause 3 of the Road Statute. Your Excellencies, it is also referred with Article 15 of the Road Statute, whether a procedure has been established in order to initiate a case. Your Excellencies, it is the onus of the prosecution to investigate a case after it is initiated, as well as collect additional information. Recently, this requirement has been stated under Article 15, Clause 1 as well as Clause 2 of the Road Statute. Your Excellency, in the instant matter, the International Criminal Court works on the principle of complementarity. Your Excellency, this principle of complementarity states that the International Criminal Court cannot supersede any national court.
Sorry to intervene. Your opening argument has been that the case is not liable to be tried by the
Indeed,
when we are at the stage where we are hearing the arguments of charge at the stage of trial.
Indeed,
Now, in terms of Article 61 of the statute, after the charge is confirmed, you know the 2 stages for the pre-trial and trial over release.
Indeed.
And at this stage of framing of the charge, the accused has a right to participate in the process and make his defense. It is only after hearing the accused that the charge is made.
Indeed.
Have you ever taken up this theme of one of jurisdiction or of the court, or you see it's what is jurisdiction of this court to try to charge in a very important time?
Your Excellencies, in the instant matter, the Moot opposition is silent with regards to the fact whether this has been taken up in the pre-trial chamber. However, Your Excellencies, in the instant matter, Article 64, Clause 9, Subclause 8 allows the trial chamber to rule on the admissibility or relevance of the evidence. Your Excellency, in the course of my submission,
just one minute. Admissibility and relevance of evidence is something different from tenability of charge or want of jurisdiction. 2 different concepts. Our question is more specific. With regard to the procedure described in the statute for the purpose of framing of the charge, and as we are in the stage of trial, hearing the arguments on the basis of the materials of record, which we consider to be evidence in support of the charge, is this theme of want of jurisdiction open? If yes, can you take us to that provision of the statute which permits it?
Your Excellency, there is no express provision in the statute to say so. However, Your Excellency, the International Criminal Court has always worked on the principle of complementarity. Your Excellency, this principle states that the International Criminal Court cannot supersede the jurisdiction of a national court.
There's no doubt of that. Our question is whether this plea was raised at any point of time earlier, and if not, whether this plea is permissible to be taken at a post charge stage when the trial is on?
Your Excellency, I'd like to answer your question in a two-pronged approach. Firstly, that the counsel for the defense agrees that there is no express provision in the law statute which allows, except the preamble which states that the principle has to be upheld. However, the fact here which the counsel for the defense is putting forth is that in the due course of our submissions, we will be proving how the evidence which is being gathered by the prosecution is not complete, and by virtue of which they have not proved their case beyond reasonable doubt.
Two different concepts. One is discharge. That has nothing to do with jurisdiction. The other is lack of jurisdiction. You cannot touch the man. Your starting argument has been that these keys are charged, these keys are trial, which the ICC cannot take up because it lacks in jurisdiction. We are only on that. Suppose, if you submit yourself with the jurisdiction of the ICC as your plan, till the stage of the charge. And if you may say that at this stage, post-charge stage, you don't have the permission to question the jurisdiction of the ICC, but it is definitely open to you to say that yes, even on the materials of the court, the evidence on the charges has been raised, it doesn't prove the charge at all, and we are entitled to discharge the case. That's a good thing. But to say that this court at this stage has no jurisdiction, is it open to urge that? If yes, can you take us to the provision of the statute? You say no. If there is no such provision, the whole trial is a creature of the statute, and it cannot be in the statute, only on the basis of the criminal which enshrines the fundamental principles of fair trial. Is it possible? Is it permissible?
Your Excellency, I understand your concern with regards to whether these charges can now be discharged. However, Your Excellency, the contention which the counsel for the defense here is making is that the ICC cannot intervene.
Just one minute. You're using the word discharge. You're not on discharge.
Your Excellency.
You say this court has no jurisdiction at all. The proceedings, therefore, is null and void. If the proceeding is null and void, you need not bother about the charge at all. You need not think about the discharge at all. It ends abortion. It's what it is. The question is, if you are at the stage, raise this question of jurisdiction, is it permissible for you to pursue this for us?
Your Excellency, there is no express bar on in the court statute. It does not expressly permit, however, it does not even expressly prohibit doing so. And Your Excellency, in the case of the prosecutor versus Thomas Vibanga Diago, paragraph 9 of this particular appeal chamber judgment, it will stated that the appeal chamber or the court at the trial stage can listen to the jurisdiction, can review jurisdiction by virtue of the fact that if a national court is willing to exercise jurisdiction, then the International Criminal Court cannot supersede that particular.
Is it your case? Has it been your case at any stage earlier? Yes, it was not bad now. See, we understand that the jurisdiction of the ICC is fundamental. The jurisdiction of the officer courts. Absolutely no problem. And if one of the states involved says that we want to try this man in accordance with our law and our code, the ICC cannot step in. It is an approach circumstances where the ICC can step in, either unwilling or unable.
Yes.
So, as because proceedings are basically of charge without any objection from the state, those states are apart. This was not raised by any of these defense, the accused persons. Is this open now?
Your Excellency, the counsel for defense is stating that the Moot proposition is silent with regards to whether this plea had been taken up in the pre-trial chamber. However, even if it had been, the counsel for defense, under the principle of complementarity, which is upheld in the Moot statute, does have backing to bring this up for discussion in another trial chamber. Your Excellency, the two main if Your Excellency could kindly refer paragraph number 7 in the Moot proposition. Your Excellency, this paragraph states that the courts in deadline were able to handle such a situation due to paucity of judges. Your Excellency, nowhere is it stated that there is a direct order given by the particular judiciary or the courts in deadline and we are unable or unwilling to prosecute President Google. Your Excellency, by not upholding the complementarity principle, my learned friends in the prosecution have failed to show that the courts in deadline will not be prosecuting the defendant number 1. With regards to defendant number 2, who is Major General Zita of the Green Pradesh, the prosecution has failed to show how he will be prosecuted in front of the International Criminal Court. By virtue of that, he is not a national of the state of deadline, which is a party to the International Criminal Court statute. Whereas he is a national of the state of Blackland, which is a totally different state, who will have the authority to prosecute him before the case is admissible or before the case comes up for hearing in front of the trial chamber or the pre-trial chamber, considering the fact that the fact of silence with regards to whether the state of Blackland is a party to the International Criminal Court statute. Your Excellency, it is the submission of the counsel to the defense that since there was the prosecutor in instant matter has not approached the courts in deadline with regards to prosecuting the matter, and they cannot bring President Zita in front of the International Criminal Court since he is not a party since he does not belong to the state of deadline and neither has he committed crimes in the state of deadline. If Your Excellency is satisfied, the counsel would like to move on with the second submission. Thank you very much. Your Excellency, in the due course of our submission, my counsel will be dealing with the fact and showing the bench evidence with regards will be showing to the bench that there is no evidence with regards to what they have charged David and Zita with. Your Excellency, Your Excellency, the counsel defense. Your Excellency, there is no.
Is it necessary that first the domestic court must be approached, or domestic court must be involved before the international ICC will be
Thank you, Your Excellency.
There are also the ICC, right? That is necessary to approach the domestic court.
Your Excellency, with regards to your first question, the facts do not clearly state that Major Zita is responsible for these crimes or has committed the crime in deadline. Basically, the court's submission will be proving that he is not responsible and has not committed these crimes. With regards to the second question, if and only if the state of Blackland would have refused on reasons of unwillingness or unable to try Major General Zita. With regards to the same, the facts are silent, and by virtue of that, the prosecution cannot assume that the state of Blackland would not be prosecuting Major General Zita, and therefore the counsel moves that there is no jurisdiction in this instant matter with the International Criminal Court.
I will try to indicate that absence of the state of Blackland in the proceedings is an indicator of the fact that the quizzes prior to the launching of the proceedings against Zita, namely the ascertainment from the state of Blackland as to whether it seeks to prosecute Zita or not, you try to indicate that the absence of the state of Blackland in a way is suggestive of the fact that these legal formality was not followed.
Indeed, not Your Excellency. The counsel is merely trying to state that the prosecution cannot assume that the National Court will not want to try Major General Zita. The right procedure to be followed under the International Criminal Court is that the prosecution must first approach the National Court in order to prosecute an individual, and if the National Court refuses or are unable or unwilling to prosecute the individual,
how do we expect us to sustain this week on the basis of the limited measures that we have? And also in the teeth of the fact that in the meantime, Charles has been saying no objection has been raised with some of the resolution of the court now. How do you expect us to judge this? Except your belief that well, nobody had approached the state of black land or red land as the case may be to try Boga and Zita. How do you expect us to decide on this on the basis of the materials? We are at a stage of hearing the arguments on the basis of evidence on the charge frame and the statute contemplates a procedure where the accused persons are given a right to participate. Is it your case that you did not participate? Is it your case the charge was framed in your absence? Is it your case the investigation was done in your absence? Was it in absentia? Or is it your case that you did not waive your right? What is your case for us? See, we have very limited materials before us. So therefore, considering the stage of the argument for us and the procedure prescribed by the statute, stage-wise, is this to be open? Can we decide? Can we take cognizance of the belief that well, neither black man nor red man was approached before by the prosecutor before proceeding against Boga and Zita in framing the charge? How do we expect us, if you have anything at your disposal, tell us, either in the fact, materials of record, provisions of law, otherwise how do we expect your argument at this stage?
Your Excellency, with regards to your query regarding whether we raised this particular doubt in the pre-trial chamber, as the counsel for defense has already stated, the Moot proposition is silent with regards to the state. Therefore, we do not know whether this plea was raised, whether it was waived, or whether it was raised and not decided upon or by the pre-trial chamber.
Can you expect the benefit of doubt on that?
Indeed,
Is benefit of doubt can a benefit of doubt be extended or any doubt?
Indeed, Excellency. However, the trial chamber is empowered to.
What is the meaning of reasonable doubt?
Your Excellency, that
If the prosecution is required to prove the charge beyond reasonable doubt, is the same benchmark applicable also to the defense? To give them the benefit of doubt?
Your Excellency, the defense has to prove that there is reasonable doubt in the case of the prosecution, and if we are successful in proving that reasonable doubt, then the entire case for the prosecution falls, and only on your
Reasonable doubt on the basis of speculation or presupposition. See, the facts as they stand today against you, vis-a-vis the stage, look at against you. There is no visible report of time from the side of the accused that we have raised the objection with regard to the judicial. But that was turned down. Charge therefore not have been framed. We have reported a case against the charge, taking his plea. Nothing is illegal to us. So, how do we accept and appreciate your argument that the ICC has no jurisdiction at all because on the principle of commonality, the prerequisites, according to you, of approving first, the concerned state government has not been complied with. How do we appreciate that argument?
Indeed, Your Excellency, what the counsel for defense here is trying to say is that in the instant matter, since this principle has not been upheld previously, this principle should now be upheld by the trial chamber and the case should be sent back to the national jurisdiction, to the national courts for red land.
Can you persuade us to hold that to uphold the at this stage, even if there is no provision in the statute, we can exercise the jurisdiction?
Your Excellency, the Council of Defense would like to draw your attention to Article number 17, Clause 1, Subclause A of the Roman Statute. Your Excellency, this particular clause states that unless the state is unwilling or unable to genuinely not try the particular accused in the instant matter, cannot exercise its jurisdiction. Your Excellency, even if this provision is ambiguous to a certain extent, Your Excellency, the Council of Defense would like to rely on the preparator of the ICC statute, under which one of the core drafting committee members, which was the state of Pakistan, had held that the International Criminal Court cannot be afforded inherent jurisdiction, and that for crimes against humanity, for war crimes, as well as for the crime of genocide, the first legal mechanism that should be approached is the national court, along with which, even if there is doubt with regards to them unable or unwilling to prosecute, there has to be a direct order or a direct direction by the national court stating that they are unable or they are unwilling to prosecute the individual, and only then the case can be instituted.
See, there is always a presumption of validity. There is always a presumption of validity of any official act. And the proceedings before the court of law are akin to official proceedings. There is therefore already a presumption of validity of the proceedings before the court. And in absence of a challenge to the proceedings, more particularly with regard to the degree of want of prosecution that you say, absence of or failure of the prosecutor to approach the state first, is it not equally on the basis of the presumption, a very fundamental principle of law, that one can very genuinely and without any hesitation hold all these formalities must have been complied with?
Your Excellency, there are no express facts in the Moot proposition which states so. And since there is an absence of these facts, we cannot presume that one or the other thing has been done. And by virtue of being the Council of the Defense, it is our duty to make sure that the water jurisdiction, the claim can be made and
we appreciate the reports, but we are trying to test the acceptability of the reports. Getting the reports all right. But you see, your reports are fully examined, scrutinized, analyzed, appreciated in the framework of law. That is exactly what we are trying to do. Not to either disbelieve or discourage. We cannot, but we are duty bound to put questions.
Indeed, the Council of Defense is merely trying to say that this principle is something that is being upheld by the Rome Statute, and it is one of in the preamble to the Rome Statute, paragraph number 10 does uphold this principle. And considering that preamble is one of the critical parts in a statute which gives the object and spirit, if it was the intention of the drafters of the Rome Statute to give it inherent jurisdiction superseding all national courts, it would have done so. However, the International Criminal Court has always upheld this principle of complementarity, and whenever there is a doubt which arises with regards to the same way factors supporting that a particular accused or a defendant can be prosecuted in a national jurisdiction, the International Criminal Court cannot supersede that particular power of the national court. That is merely what the Council of Defense is trying to state. The Council of Defense is not stating whether this particular convention has been raised before or not, because the Council is not aware since the facts are silent in this. Your Excellency, by virtue of the fact that International Criminal Court does not have jurisdiction in the instant matter, this case is fit for hearing by the National Courts of Deadline with regards to President Moot.
When we say how does it make people mean, that if things are so uncertain that we do not know whether the requirement of taking permission approaching this case concerned, their inability, unwillingness to proceed with these proceedings. But there is a doubt as to whether this has been complied with or not. First of all, we have no materials to hold that this should be upheld. If you don't have any materials to hold, then only because there is a doubt, to what extent can the doubt be clear? To hold, because this would be a decision against very serious consequences. On this ground alone, the whole proceedings would become honest, would get washed. In that context, we ask you, how does it help? Unless only on the basis of the doubt, PA is a presumption of validity of official proceedings, absence of any specific provision in the ICC, absence of any material whatsoever that this plea was earlier taken before the charge. We may even think that we are under analysis. Nothing final. Just go ahead. I think you have thought hard on this point. You have so many other points to cover. You can get lost for other points.
Thank you, Excellency. Your Excellency, the second submission that the Council of Defense is making is that President Boger is not criminally responsible for the crimes against humanity of imprisonment and severe deprivation of liberty against the people of Blue Land, which is given under Article 7, Clause 1, Subclause E of the Road Statute, and neither is responsible for causing enforced disappearance of persons from the state of Blue Land under Article 7, Clause 1, Subclause I of the Road Statute. Your Excellency, in this course of my submission, I will also be submitting as to how President Boger does not have any superior or command responsibility over the actions which have caused this particular incident. Your Excellency, under standard of proof under Article 66, Clause 2 and 3 of the International of the ICC statute, the onus is on the prosecution to prove its case beyond reasonable doubt. And in this instance, the prosecution has not been able to collect sufficient evidence or additional evidence or conduct its investigation to the point where there is proper evidence with regards to convicting the defendant number 1. Your Excellencies, these charges which have been claimed cannot amount to mere theory or suspicion, but have to be factual, tangible and concrete. And Your Excellencies, this requirement was stated in the case of Prosecutor versus Thomas Dulanga Diago, which can be referred to under footnote number 14 of the Defense Commission. Your Excellencies, in order to prove a crime against humanity of imprisonment, 5 essential elements need to be proved. And in this instance, it is the contention of the defense that the prosecution has failed to even prove one element beyond reasonable doubt to this bench. Your Excellencies, imprisonment here has been expanded to mean the condition of being detained or unlawfully confined, and is not just mere arrest. And Your Excellencies, in the instant matter, the first element of this crime, which is being given as elements of crime, states that there has to be unlawful imprisonment or confinement. Your Excellencies, the President in this instance has not unlawfully confined or detained any Blue Land civilian. If Your Excellencies could kindly refer to paragraph number 16 of the Moot proposition on page number 8. Your Excellencies, the fact that an armed group of rebels were seen transporting certain people across the border of the state of Blue Land to the state of Red Land cannot be considered to be arrest, cannot be considered to be imprisonment or delayment for that matter. And neither can be the fact that after employing a particular biological attack, the inability of the civilians to do anything cannot be construed to be imprisonment or detention. This can be stated by the fact that paragraph number 16 only talks about an armed group of rebels. It does not in any way link this armed group of rebels to the Red Land military or the Red Land paramilitary forces. And by virtue of which the prosecution has not conclusively shown this bench that it is indeed the President or under the orders of the President that this imprisonment has been caused here. And therefore, the Council of Defense submits the first element, which is essential, that there has to be an unlawful imprisonment or confinement, is not fulfilled in the instant matter. Moving on to the second element, which is essential in order to prove the crime against humanity of imprisonment. The second element states that the gravity of the conduct should basically be in violation of fundamental rules of international law. Now, Your Excellencies, in the instant matter, the President of the state of Red Land has not employed the biological attack, which the Council of Defense will be proving under the superior command responsibility issue of the defense. In the instant matter, Your Excellencies, various states permit this particular provision. Your Excellencies, Article 2, Clause 9, Subclause B of the 1993 Chemical Weapons Convention allows that gases that do not cause death can be used for law enforcement purposes. And this can be referred to under footnote number 23 of the written submissions of the defense justice. In the incident matter, this attack was mainly directed against the members of the Free Red Line Force, who were the defected members of the Red Line Army who had committed treason in the state of Red Line. And Your Excellencies, there is no conclusion.
Would you refer to the paragraph 16 of the fact sheet?
Indeed,
Where the issue of gas is referred to. It says the gas has the effect of immobilizing human beings. It would be lethal if it yielded large quantities and the gas was still in experimental stages. Scientists were quite unsure if the damage caused by the infiltration of the gas would be reversed. So would it not be covered?
Your Excellencies, in the incident matter, there is no direct evidence which gives us that this gas did result in death. There is only a mere possibility that it could. And since in a criminal trial, a mere possibility cannot amount to certainty. By virtue of that, the counsel for the defense is stating that since there is no conclusive proof that the gas did kill victims or kill civilians in the state of Uttar, President Gopal cannot be held liable for this. Further, Your Excellencies, under the issue of superior command responsibility with regards to associating gases, Your Excellencies, the counsel for the defense is stating that there is no superior responsibility in the incident matter under Article 28 of the ICC statute. Since this particular biochemical attack, if Your Excellencies could kindly refer to paragraph 16, page number 7, it clearly states that this biochemical attack was employed by Commander Major General Bahavi of the Red Line Paramilitary Forces. Your Excellencies, by virtue of this, here the council will also be establishing that this attack or this incident which has led rise to this particular case does not fall under the ambit of an international armed conflict, which the council will be substantiating in a later argument. Your Excellencies, if Your Excellency is satisfied, the council would like to move on to the third element with regards to the crime against life. Your Excellency, it is essential for the prosecution to prove that the conduct was widespread or systematic in nature. Now, Your Excellency, the term widespread connotes that a particular action of the accused must give rise to multiplicity of victims. And Your Excellency, it is a prerequisite that this act of widespread or systematic attack should not be just a random act of violence. And however, it should be through preconceived plan or policy. Your Excellency, in the incident matter, if Your Excellency will kindly refer to paragraph footnote number 25 of the written submissions of this time, it states that in the incident matter, it was only a single act which took place, and there was no element of it being widespread or systematic. There was no preconceived plan or policy on behalf of President Gopal in order to employ this attack, since this attack cannot be tied down to him, considering the fact that he did not have any superior responsibility over the actions of Commander Major General Bahavi, who is the commander of the paramilitary forces. Your Excellency, this brings me to my fourth element, which is essential, that the act should be directed against the civilian population. Now, Your Excellency, it is critical to note here that these defected members, under paragraph 60 of the proposition, these defected members of the Free Red Line Board were a part of the hostilities in the state of Red Line, and their objective in the state of Blue Line was not clear. And by virtue of this, these persons, these members, defected members of the Free Red Line Force cannot be said to enjoy the status of being a protected person or a civilian for that matter, since the fact that they were involved in the ongoing hostilities and the turmoil in the state of Red Line. Your Excellency, the next important element which needs to be proven is that the accused did not know or intend that the conduct was part of a widespread or systematic attack. Your Excellency, knowledge basically is the awareness that a circumstance exists or a consequence offence will occur in the ordinary course of events. And by virtue of which, in the instant matter, the attack was employed by Major General Mohavi and not under the orders of the President in the instant matter. And by virtue of which, the Council of Defence submits that there is no crime against humanity of imprisonment, since there was no unlawful imprisonment, neither was the gravity of the conduct severe, since it was only used to minimize the internal threat which was caused by these defected members of the FRS to the state of their land. And further, this act was not directed against the civilian population as well. Your Excellency, this brings me to my next submission, which is whether the accused has committed this crime against humanity of enforced disappearance of persons under the principle of command responsibility. Your Excellency, this principle of command responsibility states that a superior is held liable for the actions of his subordinate. Your Excellency, Article 28, Clause 2 states that the subordinate must be under the effective authority and control of the superior. Now, Your Excellency, in the instant matter, this attack was employed by the Red Line paramilitary forces. Now, Your Excellency, the term Commander-in-Chief of the Armed Forces only includes the Army, Navy and Air Force of a particular country. The paramilitary forces do not fall under this bifurcation, and they are directly answerable only to the Home Ministry, for instance, in the case of India. Your Excellency, it is a submission of the Council of Defence that the Moot proposition is silent with regards to what authority the President had regarding military and paramilitary activities in the country. And since there is no direct evidence which can link him to the fact that he is in fact the Commander-in-Chief or he is in fact the superior of the paramilitary forces, there cannot arise the doubt that he is the superior, since he is clearly not, considering the fact that the Commander, Major General Mohavi, has acted on his own accord and employed this biological attack. Your Excellency, this brings me to my next argument, which is that under Article 25 of the Rome Statute, the President cannot be held individually criminally responsible. And if the court finds that this particular biological attack is indeed illegal, then the responsibility of the same should be imputed to Major General Mohavi under the same article. Your Excellency, moving back to the issue of crime against humanity of enforced disappearance, the elements that are required to prove this particular crime are similar to that of the elements which are required to prove the crime against humanity of imprisonment. There are two main elements which are required in this instance. Firstly being that the accused has abducted, arrested, detained or confined persons, and secondly that there is a refusal to give information regarding the whereabouts of this person. Now, Your Excellency, in the instant matter, the President has not unlawfully, or for the matter has not imprisoned, confined or detained any true and civilian. And therefore the first element in this instance fails. Also, Your Excellency, the second point which the Council of Defence would like to emphasize upon is that paragraph number 16 clearly states that two journalists of the Looking Glass spotted an armed group transporting these persons across the border of Blue Land to the state of Red Land. Now, Excellency, there is no conclusive proof that this armed group of rebels did indeed belong to the state of Red Land, and by virtue of which the President cannot be held to be liable for this particular act, since there is already an ambiguity with regards to who exactly did transport or who exactly did cause this enforced disappearance of persons from the state of Blue Land. If Your Excellencies are satisfied, the Council can move on to a third submission. Thank you, Your Excellency. Your Excellency, the third submission. Your Excellency, the third submission that the Council for the Defence is that President Bober is not liable for the war crimes under Article 8, Clause 2, Subclause A, as well as B respectively. Your Excellencies, firstly, the Council of Defence will be, if Your Excellencies could grant me an extension of 3 minutes, I would like to sum up that the common elements that are required for war crimes have not been conclusively proven by the prosecution. Your Excellencies, I would like an addition of only 2 minutes instead of the required. Immediately. Thank you, Excellencies. Your Excellencies, there are 4 core elements which need to be proven under war crimes. The first being that the act should amount to international armed conflict. Your Excellencies, my learned friends from the prosecution could not establish this, which is exactly the submission of the counsel for the defense. In the instant matter, in the case of military and paramilitary activities in and against Uttar, the ICJ had held that in a particular conflict, it is not the territory of the conflict that matters, but it is the parties to the conflict that need to be seen. Your Excellencies, in the instant case, it is the 2 parties to the conflict are the state of Red Land and the defected members of the Free Red Land Force. And by virtue of which these defected members are themselves nationals of the state of Red Land. And therefore, there cannot be an international armed conflict between a non-governmental armed group and the government of the state. It can only amount to an armed conflict or a non-international armed conflict, by virtue of which this makes it an internal matter of the state of Red Land. Your Excellencies, this element is essential in also proving the fact that the biological attack which was targeting these defective members was in fact an internal matter between the defective members of the FIS and between the state of Red Land. Your Excellencies, the next element which is important is that the persons who were targeted have to be protected persons under the Geneva Convention of 1949. Your Excellencies, in order to the prosecution of a grave breach requires substantial proof that the victim of the crime falls under this definition. And Your Excellencies, this particular requirement has been held in the case of Narrative et al., which is reference to footnote number 50 of the Commission of the Record. Now, Your Excellencies, protected persons include that persons who find themselves in the hands of the occupying power of which they are not nationals of. And Your Excellencies, in the instant matter, these defected members of the FIS are not in the hands of the state of Uttar. They are merely refugees that have crossed over the border of the state of Red Land across the state of Uttar. Further, Your Excellency, Article 33 of the United Nations Convention on Refugees 1951, this article has an exception clause. Clause number 2 states that if a particular refugee is seen as a threat to the country in which it has attained this refugee status, then the principles of refoulement will be upheld and the defective members can be refouled by the country in which they have obtained refugee. Your Excellency, basically demonstrate the geographical and temporal scope, which brings the Council back to the first argument that it is not an international armed conflict, since there has been no backlash or no answer by the state of Uttar to these activities of the state of Red Land. To actually the last element that is required for proving a war crime is that the perpetrator should have been aware of the factual circumstances. The Excellencies, in the instant matter, President Gogol does not have any superior responsibility. Your Excellencies,
our experiences makes us in case it is time for the answer. We have to indicate to put your brakes. Now I think that there is no more thing we have to stop.
Presently, the Council is very safe and have co-counsel will now go up and defend the charges, third and fourth charges against illegal. Thank you very much.
With a new voice and a new position. She is here.
Your Excellency, a very good evening, Excellency. It is an absolute honor to argue before you. Your Excellency is the second counsel for the defense, with primarily protecting the issues that have been alleged against religious elements. In this regard, firstly, the counsel for the defense will be dealing with the crime of genocide under Article 6 of the Road Statute. And in this regard, the Council will be making primarily three submissions. First, that the members of the San community do not constitute a protected group under the purview of the Road Statute. Secondly, that the evidence that has been adduced before the court today is not conclusive to attribute the crime of genocide to Major General Zita. Thirdly, that Major General Zita did not possess the requisite specific intent for the commission of the crime of genocide. And finally, in argument, if the court is not satisfied with these arguments, that Major General Zita A did not retain effective control of the green units, and B cannot be held individually criminally responsible for the same. Your Excellency, moving to my first submission, under Article 6A of the Road Statute and under Article 2A of the Genocide Convention, one of the most important elements of genocide is that firstly, it is not a random act of killing against a collection of individuals. It must be directed against a protected group. Now, in order to produce what this definition of a protected group actually is, reference is being made in this regard, Your Excellencies, if you could refer to footnote number 95 of the defense written submissions, to the International Court of Justice's advisory opinion with respect to the application of the Convention on Prevention of Genocide. Your Excellency, in this regard, the ICJ has stated that the protected group necessarily must be positively defined and not negatively defined in relation to or in comparison to the characteristics of another group present within that area. Therefore, for example, the elimination of Muslim Croatians within a particular area would constitute genocide. But the elimination of Muslim Croatians would not constitute genocide if they were targeted by virtue of the fact that they were not Serbians or not Bosnians. So the idea behind targeting a particular group, Your Excellency, cannot be in relation to another or to the characteristics of another group. In this regard, Your Excellencies, if you could be so kind to read with me line number 4 of paragraph number 13 of the Moot Constitution. It says, and I quote, that Major General Zita wanted to purge the rest of the world from immunities by eliminating people of religions other than North Star Orthodox. And this line is very, very important in the context of the argument that the defense is making, Your Excellencies, because it clearly tells you that the members of the San community, among other communities, were targeted by virtue of the fact that they were not Orthodox North Star community members, and that is the definition of a protected group that is negatively identified, and therefore, Your Excellencies, does not fall under the definition of a protected group that has been prescribed by Article 6 of the Road Statute and Article 2A of the Genocide Convention. That's our first primary. Our second submission in this regard, Your Excellencies, is that the evidence that has been produced before the International Criminal Court today is not sufficient to attribute any of the crimes complained of to Major General Zita. Your Excellencies, a few points of law in this regard. Firstly, under Article 66(3) of the Road Statute, it becomes very, very clear that the prosecution has to establish all acts of criminality attributed to the alleged perpetrator beyond reasonable doubt. Your Excellencies, the standard that has been set for this kind of evidence in international law is extremely, extremely high. If you look at the International Court of Justice's opinions in the landmark case of the Portugal between the United Kingdom and Albania, it says that whenever a charge is brought out against a person, and such a charge is of great severity, then the evidence that supports that charge must conclusively provide a causal linkage and therefore be a method or modicum of attribution of the crime to the alleged perpetrator. The application of the Convention of Genocide case that has previously been referred to has upheld this standard of evidence in the case of genocide. The flinching bit of law that rules the case or should rule the case in our favor in this regard is the opinion of the International Criminal Court itself in the Thomas Longer judgment. If you could please refer to footnote number 106 of the defense's written submissions. Thomas Longer case lays down two principles for which it should be required for evidence to be accepted or to be held admissible in the ICC. First, that the evidence must contain an element of probative value, and secondly, that it must be reliable. Your Excellency, with respect to probative value, it is submitted that in the context of the crime committed and the problem before us today, probative value would imply that the evidence is capable of some degree of attribution. And with respect to reliability, Your Excellencies, it is subtended before you that for the evidence to be reliable, the circumstances surrounding its collection must be taken into account in order to discern whether it is free from tampering, corruption, or collection under grounds of duress, all of which find, Your Excellencies, are grounds under which evidence has been ruled inadmissible by the ICTY and the ICTR, the precursors to the International Criminal Court. Your Excellencies, coming out of a factual analysis with regard to these points of law. Firstly, with respect to the probative value, we find that all the video clips that have been presented before the court today do not specifically show the members of the Green Berets committing a crime. They do not specifically show Major General Vija making any kind of a statement. In fact, Your Excellencies, the fact sheet, as a matter of fact, refers to the perpetrators as alleged perpetrators. It refers to the voice of the alleged perpetrator as an unknown voice whose face could not be identified. All of this you would find under paragraphs 16, 17 and 14. They have been mentioned extremely clear. And in this regard, we tell you that there is no probative value with respect to the evidence that has been produced. Further, Your Excellency, it has been held that under international humanitarian law and the law of the ICC, which has been derived from the special tribunals of Rwanda and Yugoslavia,
Would you argue with reference to Article 69? Because Article 69 does not appear to be so narrowly worded as you are trying to canvass.
I will ask you just 1 second to refer to it and then. Your Excellency, which is the paragraph that you would like the council to cover? Indeed. Your Excellency, this paragraph primarily talks about the element of probative value that the council has brought across. Your Excellency, while the ratio or the data that I have just given before you from the Thomas Obama prosecution might seem narrowly worded, the idea behind it, Your Excellency, derives from a well-established principle of international law that for a charge with great severity, the evidence must also be a lot more conclusive than the crime of an ordinary nature. Because, Your Excellency,
don't you think it's worded to the contrary? And maybe that same principle which applies to an individual may not apply in case of war crime.
Your Excellency, it is with regard to how the section is worded.
Why do we like it? Because it's a crime which takes place in your country. The prosecutor is not there. You have not prosecuted anybody for it. You have done no investigation. So what is the material available? The material is going to be video clips, statements, etc. And nobody is going to be there available on the site because no forensic evidence was collected. So the entire this form would have to be read in that form. This is our question.
Absolutely. Your Excellency, with respect to reading paragraph 4 in that context, paragraph 4 must also be read in context of the fact that the crime being alleged here is not mere murder against an individual. It is a crime of genocide. And for genocide, the evidence itself provides such a high burden for the prosecution today. The evidence must therefore be consonant with the burden that has been provided under the statute. And Your Excellency, we might find that the ratio that the council has just laid down is narrowly worded. But it would not seem to be narrowly worded only if you look at the words of 69(4) in context of the elements of crime with respect to genocide. Your Excellency, genocide by killing involves, among other things, the requirement of a specific intent. Now, Your Excellency, with respect to such actors' lists and with respect to such specific intent, it may be submitted that unreliable evidence can greatly cause a vitiation of trial. Yes.
So there is 6 also. In some clause 6.
Your Excellency, paragraph 6 of Article 69 says the court shall not require proof of acts of common knowledge, but may take judicial notice of them. Your Excellency, a fundamental distinction that the council, in his opinion, would like to draw is that if this is a fact of common knowledge, the Moot proposition would not explicitly have spoken about the video talking about the perpetrators. It would have stated it as a matter of fact. And then, of course, Your Excellency, the court would have taken knowledge of the same. Now, Your Excellency, before the council today is the Moot proposition. The Moot proposition tells the council that the videos have shown the alleged perpetrators. And therefore, it is submitted, Your Excellency, that the same cannot be taken as a matter of fact or common. Yes.
If you come to the Moot proposition, the facts mentioned in paragraph 13 onwards are the facts which are established. These are facts which are true. I will just see 13 for a moment. Read 13.
From the beginning, Your Excellency?
Yes. An extremist army of men of Orthodox North Star community headed by Mr. Zika, a self-styled major believer in the use of force, considered to be a religious leader, unleashed a campaign to purge the state of Blackland and the rest of the world from impurities by eliminating people of religions other than North Star. They won't read. They wanted to establish a state purely for North Star Orthodox community. Now, if we go ahead, paragraph 14, he establishes an army. Then, mass beheading takes place. All are against non-Orthodox staff. Then, if you see 15, Greek parade is army continue targeting non-Orthodox staff and non-star community members of the Sun community. Then come to 16 end. After the infliction of that gas, men of the Greek parade opened fire on the already unconscious crowd with automatic rifles. Then they were dragged. Then a video is uploaded. Now these facts are proved. Will these facts not establish genocide?
Your Excellency, the reason why these facts will not establish genocide is that you must, it is a humble request to Your Excellency to read these facts in light also of the fact that one of the primary elements of genocide is that the killing of such persons must be attributed to the alleged perpetrator. If I could read the same lines that Your Excellency has cited, just paragraph 14, that's all. Your Excellency said that soon the logic is to be extremely large and very severe. It is because of the acts that are being complained of, Your Excellency. Like the Council has already stated, the act of genocide is not a mere random wanton killing. It involves several additional elements, including repeated killings with a specific intent to obliterate a particular group. And therefore, Your Excellency, if any circumstantial evidence is to be adduced before the court, it must be such that it is capable of making a causal linkage that or whose attributed quality is present within that evidence itself. Your Excellency, the video is read in light of the facts too. In a situation where Redland and Blackland were in constant turmoil, cannot be enough for the attribution of such crimes to Major General Zita and the people.
That is on the basis of circumstantial evidence. But why should we invoke 6 and take judicial notice of facts that you are not denying? You are not denying these facts.
Your Excellency, even if the court were to take notice of these facts as common knowledge under paragraph 6, the court would be unable in this regard to draw a link of attribution between these facts of common knowledge and Major General Zita. Your Excellency, it is submitted that Major General Zita has made certain statements. He's made certain statements to the effect of creating a pure state. In light of these statements, certain acts have occurred. Now, Your Excellency, 2 elements need to be established here. Firstly, that the Green Berets have committed these crimes, which, even if the court accepts as common knowledge as facts under Article 69, paragraph 6, it would not be able to establish it because there is no attributive quality present in the evidence that is adduced before the court. And secondly, Your Excellency, and this is something that the Council of Defense would come to in just a second, it would also have to make the logical linkage that Major General Zita should be held individually criminally responsible for the same, which is altogether a different aspect of the law and therefore requires further introspection. Your Excellency, if I could move to my third submission with respect to genocide, if the bench is not objections. Your Excellency, the fundamental element of mens rea with respect to genocide is that of global speciality. How is global speciality different from consequences of a particular act. But role speciality requires that you target a particular group with the specific intent to obliterate the same, and accompany this intent obviously is accompanied by deliberate and willful acts to obliterate this particular group. Your Excellency, if you would refer to footnote number 145 of the memorial submission of the defense, it talks about the cases of German, Katanga and Yelish, two landmark cases of the ICBR and ICTY, which has spoken at length about how high burden specific intent or role speciality is and what are the requirements for proving it. In this regard, Your Excellency, we already spoken to you about the negative identifier that is present with respect to the San community. Just reiterating that in a few short sentences before I move on. The San community in this regard has been targeted not by virtue of the fact that it belongs to a particular ethnicity or not by virtue of the fact that it contains certain religious characteristics. The reason why the San community has been targeted, Your Excellencies, is primarily because it is not an orthodox non-star community. And in that regard, you would notice that the element of targeting other communities as well, such as non-orthodox non-star, is of great importance in this regard. The Council for the Defense is not trying to suggest that this targeting must be exclusive to one particular group. But once this target encompasses a wide variety of groups by virtue of the fact that they lack certain characteristics, it cannot then be termed as specific intent required for justice. And that is a harmful solution. Your Excellency, now coming to individual criminal responsibility. Your Excellency, we would be challenging criminal responsibility under two articles here, Article 25 of the Road Statute and under Article 28 of the Road Statute. In this regard, we submit that firstly, principally, under Article 25, the idea that must be established before the Honorable Court is that the alleged perpetrator has aided, abetted, or solicited the commission of any crime by the alleged perpetrators. And secondly, under Article 28, Your Excellencies, the principle of superior responsibility in this regard becomes very, very important. And therefore, we must establish effective control of the commander over his troops. Your Excellencies, just coming to briefly the principle of effective control. And if you could, Your Excellencies, refer to paragraph number 30 towards the last line of the Moot proposition. The last line of paragraph 13 brings out a very important fact before us, that there are several reports by international experts that the believers were being trained and supported by members of an international terrorist organization. Now, Your Excellencies, if we actually look at this subject in great detail, we find that the Nicaragua case of the ICJ has laid down that for effective control of your troops, you must be able to train and support them among 5 other elements. So these two elements, Your Excellencies, are clearly vitiated in this regard, and therein we submit to you that our burden to prove this to you, or our burden to put forth to you reasonable doubt with respect to the controlling power of Major General Zita with respect to the Green Berets has in this regard been satisfied. Therefore, among other things, and in complete argument, if the court is dissatisfied with the arguments presented by the defense with respect to the elements of the crime of genocide, it is a humble submission that the court should not hold Zita liable because it did not retain effective control over the troops of the Green Berets. If Your Excellencies are satisfied with the arguments, the Council would like to move on to the second submission. Thank you. Your Excellencies, the second submission deals primarily with crimes against humanity and whether or not Major General Zita had committed the same. The crimes against humanity that have been alleged by the prosecution today are Articles 7, 1, A, B, and H of the Rome Statute, which are essentially murder, extermination, and persecution. Your Excellency, the fundamental and basic requirement of a crime against humanity, and this you would find if you would refer to the elements of crime of the Rome Statute in the first paragraph of Article 7. It says that the attack itself must be widespread or systematic, giving it a disjunctive meaning. The Council of the Defense will now prove that this attack against the civilian population committed allegedly by the members of the Green Berets were not widespread or systematic to be hit by the relevant provision of the statute. Your Excellency, with respect to a widespread attack must be one whose magnitude is of inhumane nature and is so extraordinary as to spread its tentacles across the international community and show that it is of indeed a great nature. Your Excellency, if we refer to the systematicity of any act, and this is where the Council would be again relying on the arguments, on the opinion of the ICTY in the Tinomet Blasche case. The core requirements of an attack being systematic are firstly the existence of a political objective. Secondly, the requirement of a crime being committed on a large scale to weaken a particular community. Thirdly, the use of significant public and private resources and all. And fourthly, the implication of high-level military authorities and commanders in the methodical establishment of a plan. Your Excellency, our primary condition in this regard is that the fourth element in this case is not satisfied. Now, if you were to take a very cursory glance across paragraphs 13, 14, 16 and 17, you would find that mention of Major General Zita is limited to the laying down of a broad ideology of creation of a pure state by eliminating all those who do not conform to his religious faith. In this regard, Your Excellency, you submit that the requirement for a detailed and methodical plan and the implication of high-level military authorities therein has not been satisfied. Which is why we brought up, Your Excellency, the point about effective control having possibly gone on to an international terrorist group. In order to elaborate on this, let me just add a few short sentences. Firstly, Major General Zita in this regard cannot be held liable simply because the idea behind proving this is essentially that Major General Zita's name does not feature in any of the or cannot be shown with respect to the evidence provided to us that Major General Zita has laid down a systematic and methodical plan for this act to be a part of a larger collective, as opposed to a fundamental broad ideology, which Your Excellency, this is the Council's humble submission, would be too broad a platform to classify so narrowly under this definition of a systematic crime. Furthermore, Your Excellency, in this regard, we submit very clearly that Major General Zita's involvement in these crimes cannot be established beyond reasonable doubt under the principle laid down in Article 66(3) of the Rules Act. And in this regard, we submit, therefore, Your Excellency, that the first and foremost requirement of the elements of crimes against humanity have not been met. Perhaps you would come up with, Your Excellencies, a problem with this contention with regard to paragraph number 16, where the green grenades are fired upon an unconscious crowd of civilians. The answer that the Council for the Defense poses to that question is very, very simple. The evidence before us does not tell us what the composition of that crowd was. And therefore, it is impossible for the court to adduce as to whether that piece of firing was committed as a part of a larger political objective or a part of a larger methodical plan. And in the absence of this large image being visible to us today, we submit humbly that there are no crimes of humanity that have been committed. In order to establish the individual elements of the crime, the Council will not be taking too much of the first time anymore. However, with respect to Articles 7(1), A, B and H, the essentials of which have already been elucidated upon by the prosecution, we find that the ruling of the ICTY in the Delanich case is very, very important. And if you could refer to footnote number 146 of the written submissions of the defense, you will find that the defense has made a contention that in order for murder, extermination or persecution to be conclusively attributed to a person, there must be causal linkage that is shown in the evidence. And this is a prerequisite that the ICTY has conclusively laid down in terms of international criminal law. Where is that causal linkage, Your Excellencies, in the present regard? The defense humbly submits that there is none. In the absence of this causal linkage, in the absence of this attribution that is available before the court today, there is no doubt, Your Excellencies, or rather to the contrary, there is more than reasonable doubt as to whether Major General Zita can be implicated for the same. Further, Your Excellencies, with respect to command responsibility, with respect to whether Major General Zita knew, had knowledge of, or could have taken reasonable steps to prohibit or prevent the commission of these crimes, it is our humble submission once again that reference be drawn to the last line of paragraph 30. Your Excellencies, reports of international experts can never be taken lightly. In fact, the ICJ statute recognizes the reports of international experts as a source, a fundamental source of international law under Article 38(1) of the same. By the reports made by these international experts, we come to know of a very simple fact that perhaps there is a larger force at play here, of which Major General Zita is probably just a figurehead. Is probably someone who's merely positioned as the front for an operation. That is something again that would possibly border on speculation, but is important nonetheless. It is important only because speculation in this case, Your Excellencies, serves to promote our purpose. When we tell you that speculation can implant reasonable seeds of doubt within Your Excellencies' minds when you come to actually bringing about or expounding upon the merits of this case. In this regard, we tell you that effective control has not been satisfied, and in the absence of such effective ingredients.
The facts state that he is self-proclaimed religion. And there is a policy which is specified in the fact sheet to the man. Given this policy that he wants to purge, and given the fact that he has walked out in one sense to proclaim himself vegetarian and promoted free marriage, what other purpose could you possibly have?
Your Excellency, no.
What is the other purpose of the person who makes that purge this particular community out of your state, proclaim himself a major general in fire force?
That's the policy. Your Excellency, Your Excellency, with respect to a systematic act of violence against a civilian population, evidence can be circumstantial only to the extent that a certain level of attribution is available in that evidence. Your Excellency, you humbly concede that Major General Zita has made certain speeches where he has laid out a broad political objective. Your Excellency, however, as we spoken to you about from the last two cases, the fourth element of the same, this element may not just be a vague or a general idea of what the person wants to do. And therefore, Your Excellencies, for implication under crimes against humanity, that element of political objective must be substantiated by the implication of the same person in the methodical planning and establishment of the same. Your Excellencies, when we come to paragraph number 13 in the last time, we realized that the Green Berets in this regard have completely been trained and supported in their operations by an international terrorist group. And therefore, it is not possible for us to conclusively make that link from A to B that as a result of Zita's political objectives, the actor-stress can now be attributed to him, or he can be implicated in the formulation of a detailed plan to get rid of members of the Sun community or non-Orthodox non-Star community. And that is the primary contention that the counsels for the defense are making.
You don't dispute the video clippings made or uploaded by the alleged perpetrators of the crime of the Green Berets?
Your Excellency,
admitting the involvement of Zita, you don't dispute that?
Your Excellency, let me answer that question a little differently. I do not dispute that the alleged perpetrators of the crime have named Zita's objective as well as what covers them. But for Zita to be held individually criminally responsible, either the video must show him killing people or the video must show the Green Berets killing people. In this case, without making that link of the conviction of the Green Berets, therefore leading to the individual criminal responsibility of the
you have to consider the entire evidence together. The facts will be together. There has to be cumulative consideration. One fact leading to the other. And then only maybe if you take this video upload should be some kind of an admission by the members of the Green Berets who allegedly have been used by Mr. Zita to commit these atrocities. Will it not be a situation where the accused is not being compelled to give any evidence against him? It's a voluntary admission on his part. Will this evidence not be admissible in the context of Article 69, 4 and 6 together? And also keeping in mind that law is only a means to an end. Justice has to be done. There has been massacre of innocent civilians, human beings. So to keep with the killing of persons, innocent civilians. Is it not permissible?
Your Excellencies, if I may answer the question. Your Excellencies, it's very interesting that you brought up the spirit of the ICC. And here we bring out a very fundamental distinction. Firstly, the spirit of the ICC is enshrined under Article 66(1) of the Rome Statute, which says that the accused is presumed to be innocent unless proved guilty beyond all reasonable doubt. Let's also look at the kind of barriers that have been laid down by the ICC in terms of prosecuting people with respect to crime of great severity. The ICC statute understands that the requirement for the commission of genocide involves an element wider or higher than normal men's that is towards specialists. And therefore, Your Excellency, in light of the preamble of the ICC and in light of all the substantive provisions made out in the ICC and the elements of crime, if we were to distill a fundamental object and purpose of the ICC statute, it would be to accuse those alleged to have committed crimes, but not unless their guilt is established before the court beyond all reasonable doubt. And in this regard, the defense counsel completely agrees with you when you say that each fact is linked to the other. We tell you that the primary linkage that has to be drawn between Major General Caesar and the death of these victims is the commission of these crimes or the existence of a certain degree of actus reus on the part of the Green Berets. Even in that sense, we tell you, Your Excellency, that even when the Green Berets or if the Green Berets are possibly convicted of such a crime, Major General Caesar's effective control over the Green Berets can be disputed. And therefore, under no circumstances with respect to the three-pronged approach that the Council has already pointed out, can Major General Caesar be held individually responsible for the crimes of genocide or for the crimes against humanity. Yes, and with that, Your Excellency, the Council has come to the end of the submission. If there are any other questions or questions. Your Excellency, would the bench like the Council to reiterate the prayer? Thank you. Your Excellency, the defendants, in the light of the given facts and submitted contentions, ask if it may please the court to adjust and declare that the International Criminal Court, firstly, does not have any jurisdiction in this matter. Second, that President Mr. Bogo is not guilty of the crimes against humanity of imprisonment and enforced disappearance under Articles 7(1)(e) and I, respectively, of the Rome Statute. That President Mr. Bogo is not guilty of the war crimes under Articles 8(2)(a) and B of the Rome Statute. That Major General Caesar is not guilty of the crime of genocide under Article 6 of the ICC statute. And finally, Your Excellency, that Major General Caesar is not guilty of the crimes against humanity of murder, extermination, and persecution under the principles of command. Thank you, Your Excellency. This has been an absolute honor and privilege.
Just 1 minute.
English of your demand.
Your pardon, Your Excellency?
1 minute. Because, mercifully, we are not required to decide the matter. We are only required to decide the performance. So, we have seen the performance of both sides. We would allow you to complete the formalities. 1 minute duration.
Your Excellency, firstly regarding the issue of the jurisdiction that was raised by the defendants, Your Excellency, they submitted that this is an issue that should have been decided and must have been decided at the pre-trial chamber level. Further, Your Excellency, the defendants have alleged, Your Excellency, that the matter should have gone to the Reverend Court. Your Excellency, the Assembly submitted in paragraph 7 of the fact sheet clearly states that the Reverend Courts were ill-equipped to deal with any such matter due to a paucity of judgment. Hence, Your Excellency, the matter concerning Mr. Booker should and has, Your Excellency, come before the Council Court. Further, Your Excellency, the defendants also say that Major General Vita does not come under the jurisdiction of this court because Blackland is not a party or a signatory to the Rome Statute. Your Excellency has submitted that the crimes committed by Major General Vita occurred within the territory of both Blackland and Union as clear from the achieved. In accordance with Article 12, Clause 2, Subclause A of the Road Statute, Your Excellency, Major General Rita also comes under the jurisdiction of this Honorable Court. Much obliged, Your Excellency.
Your Excellency, just one point, sir. The 1 point, sir, department is very important. Is essentially that in the case of Thomas Lubanga dialogue, in paragraph 9 of the judgment, and this is available for the bench's perusal. In paragraph 9, it is said that the challenge for jurisdiction can go as far as the appeal chamber, and therefore the trial chamber is the link that is below. And in this regard, we submit therefore that jurisdiction is an issue that, unlike municipal contest, is heard elsewhere as well. Thank you.